Good afternoon, everyone, and welcome. We're pleased to have you with us. We have 4 cases on the afternoon docket. They will be heard in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes, and that applies even if more than one counsel is arguing for the appellants or the appellees. The appellants do have the option of reserving up to 5 minutes for rebuttal. So when the appellant's counsel comes to the podium, after you've introduced yourself, please tell us how many minutes you wish to reserve, and the clock will be programmed accordingly. As you know, the Court of Appeals of Tennessee is one court, and there's 12 of us across the state. Judge Bennett and I are honored to be sitting with our colleague from West Tennessee, Presiding Judge Steve Stafford. We're pleased to have him with us, and as a guest, we've made sure that he has been assigned the most difficult cases on the docket, so we thought that was only fair. So anyway, but are there any announcements or introductions? Hearing none, please call the first case.
Vicki, Marlene, Almond Road, Taylor versus Jack Elmer Taylor, Jr.
Good afternoon.
Good afternoon, Your Honors. May it please the Court, Ben Lewis on behalf of the appellant Jack Taylor. And if it may please the Court, I would like to reserve 4 minutes for rebuttal.
4 minutes, yes, sir.
Your Honors, as I mentioned, I'm here on behalf of Jack Taylor. This case stems out of a Cannon County Chancery Court divorce matter that was tried in 2022. The parties were married for approximately 10 years, had no children of the marriage that were minors, and the divorce centered mostly around the distribution of the marital estate and the classification of separate property, marital property. The individuals in this case were older at the time, and they had been married previously, came into the relationship with several items of property that were relevant for the court to determine whether they were separate or not. For our appeal as the appellant, we've identified 2 issues for this court's consideration. The first issue is whether the trial court erred in classifying property as marital or separate and valuing that property, and if the trial court failed to classify certain items entirely. The second issue is whether the trial court erred in making an equitable distribution of the party's entire marital assets and debts. As an initial matter, to point out, included within our brief for the appellant is a Rule 7 table as required in all domestic relations cases. I want to note, just to go ahead and address it at this time, that many of the facts regarding the distribution of properties, the values thereof, were cited by myself on behalf of the appellant in my Rule 7 table and noted within the statement of the case and facts. I think that's appropriate for purposes of a case centering mostly around the distribution of the assets.
While you're talking about valuation, one of the comments that the trial judge made was that the 2 parties, and these will be my words, not the judge's, did a poor job of providing evidence of the value of the respective assets. Aside from the fact that that makes the trial judge's job difficult, how can this court deal with that?
When it comes to the items that we take issue with in our appeal in terms of valuations, Your Honors, some of the ones that are most difficult for the trial court at that time and this court to address would be the firearms that we take issue with. Very limited, if any, testimony really as to what the value of those were at the trial. But the issue we take precedes the valuation of those, which is that the majority of them were premarital assets based upon undisputed testimony. So we don't even have to get to valuation other than maybe for the marital estate itself. Don't necessarily have to get to the point of valuation for the distribution of those assets because our position was they were incorrectly determined to have been marital assets. As to some of the other items,
were those firearms identified?
Our position is they were because there was a list of firearms The only firearms the court identified within its order were the ones listed upon an exhibit provided by the appellant, both at a motion hearing previously and attached to his 12.02 statement under our local rules. In that's the only items that the court identified as being firearms that were distributed amongst the parties. There was testimony by the husband, Mr. Taylor, that he had potentially other parties had possession of firearms, which the court, for lack of a better word, took offense to, that had not been raised prior to late in the trial. However, the only ones that were distributed were the ones identified within his 1201 statement, 1202 statement, and provided in a list. And but those did not. The testimonies, the evaluations came from during the trial, not on that list itself.
How many firearms were actually identified?
I would have to look. There were, if I recall correctly, there were about 15 or 16 firearms specifically identified. Some are. I made a footnote on page 12 of my brief that there were a couple of items that were duplicated, I believe, and incorrectly listed based off of the actual exhibit that was provided. But if I recall correctly, there were about 15 or 16 firearms in total. And some of them, about half, were provided as separate property to the husband. Some were undisputed to be marital property, and then there were some that Mr. Taylor undisputed testimony was that they were premarital assets, but the court deemed them to be marital. So that's where we take issue with the division of those weapons.
And have you identified those specifically?
We've identified the weapons that were distributed in our Rule 7 table, the ones that were separate, the court deemed to be separate, and the ones that the court deemed to be marital property. Yes.
So the ones that you're actually contesting, though, have you?
Are the ones that are listed as marital property, Your Honor. All the ones that are listed as marital property that don't have there's a citation on some of them that are listed as uncontested. The ones, there are 2 AR-15s purchased with receipts provided during the marriage. My client did not argue that those were marital property. The other weapons that were listed on there, I believe there's Remington Model 12, and there's several of them listed that were considered marital property we take issue with. I hope I answered Your Honor's question. It was a few minutes ago. I apologize. I want to also point out, before getting into it, that the trial court made no oral findings in this case. It was limited entirely to a written ruling the court issued several months later. So when it comes to citations to the record, those citations would all be to the court's written findings in 2 separate, an initial final judgment of divorce and a subsequent amended one that are found in the volume 2 of the technical record. We've already touched on the firearms, so I'd like to move on past that. One of the major issues that we've identified as a misclassification or failure to classify an asset relates to the wife's 401k and her stock in HCA. The court found in its ruling that the value of the marital portion of the 401k was $90,639.21. During the trial, the wife's testimony was she took out 2 loans against that 401k during the pendency of the divorce in the total amount of $63,000. The court does not address those loans in its final ruling, although it was contended that those should be rolled back into the 401k for purposes of distribution. The wife testified that those loans were for upkeep of the farm during the time that she was in sole possession, which I believe was about 14 months during the pendency of the divorce, and she used those for legal fees during the pendency of the divorce. Wife was later awarded by the court judgments for the upkeep of the farm and the mortgage during her time in an amount, I believe it's around $28,000 of a judgment against the husband for mortgage and upkeep and things of that nature. It's our position that essentially what the court did was allow a double dip of that amount to the wife by awarding a judgment to her for those amounts off the top of the marital estate, while also failing to consider loans that she admitted from her 401k were used for those exact same expenses. So the easiest way to reconcile those two things would be roll back in the loan, and if the judgment stands, then it stands, but there wouldn't be a double dip if those loans were rolled back into the 401k. It's our position that the court erred by not considering or making any ruling at all upon those loans that were taken from the 401k. And it's our position that that was an error. Those should have been considered as part of the marital asset of the 401k. There was a small, approximately $12,000 amount that was undisputed to be premarital because the total value of the 401k at the time of trial, as shown on an exhibit to trial, was around $100,000.
Are the loans still outstanding? that she took from the 401K?
I'm not certain if they're still outstanding, but they were awarded, the entire 401K was awarded to her, along with presumably those loans as well. So whether they're outstanding or not, I don't have any knowledge at this time, Your Honor. There was further testimony during the trial that the wife had around $8,800 in HCA stock, and that was never classified and never dealt with by the trial in its final ruling as whether it was separate marital or whether it would be divided at all. It's our position that that essentially went to, and we've included that in our total valuation of the estate when it was divided, that by default went to the wife, although it was not determined to be marital or separate property. Then, Your Honors, we get into several issues we have with valuations, and I'll go to, I think this touches back on Your Honor's statement earlier of how do we deal with valuations when there's little testimony on that. The issue we take with the valuations is that many of these items were husband's property that he had purchased during the marriage. Vehicles, tools that he'd come into the marriage with, things of that nature. And admittedly, the burden is on the parties to prove through competent testimony what that valuation may be. And the parties themselves have the ability, it's well settled, to put a value on their own personal property. However, I think the key word there is competent testimony. The court took into account different valuations from the parties in several instances. Most clearly would be the tools that husband testified to. On one hand, he testified, and it wasn't disputed, that he came into the marriage with those tools. He came to the marriage with basically a building size of tools that is still there on the property and was there at the time of the divorce. Regardless, the court took those tools and simply said, that's marital, we're gonna consider those a marital asset. However, when it did an evaluation of those items, it took husband's value, which he valued those items to be, if I recall correctly, about $18,000 on the tools, $15,000 on the tools. The wife valued them at $50,000. On its face, that would appear to be different valuations the court has to reconcile. However, on further cross-examination, the wife testified she came up with her value, quote, out of thin air. When you come to competent testimony evaluation, Your Honors, I don't understand how that could possibly be considered competent testimony when she does not testify that she has ever used them, has no knowledge of them, anything of that nature. She even testified she couldn't use them, had to buy new ones during the divorce to kind of be able to mow her yard, etc. So the court then took the middle number between those two, set a value of $32,500, and awarded that to husband, all of his tools. But in doing so, awarded him more of the marital estate, which in our position was essentially fiction. And that goes to several items, specifically including debts and assets that the parties had, that we posit the court took valuations that the wife submitted. She had no clue about those and simply said, I'll take the two and split the difference, even though there was no competent testimony on wife's part. So, and I'll see my time at this time. Thank you.
Thank you, Mr. Lewis. We'll hear from you again on rebuttal.
Yes, sir.
Good afternoon, Mr. Payne.
Good afternoon, Your Honors, and may it please the court. My name is Jeffrey Payne of the Rutherford County Bar, and I represent the appellee wife in this case, Vicki Taylor. I think an overarching theme of this case, and it's pervasive throughout the record and the trial court's rulings in this matter, is that the appellant husband in this matter is completely devoid of credibility. His words and actions throughout this litigation are demonstrative of that fact. His deceptions and his evasions, both at trial and well before, were multitudinous and extensive. As early as June 2020, a couple years before we actually had a trial in this case, the trial court entered an order where it found that the husband was not credible regarding his income and expenses, and of course that carried through on into the trial. The court also found that it had a hard time believing that husband would follow the court's orders. And you fast forward to the end of the case, and in its final ruling, the trial court listed many examples of husband's lack of credibility. One example was this crazy letter that he sent to wife's employer. He sent this letter posing as wife's anonymous co-worker, and this was all a blatant attempt to get wife fired from her job. Disturbingly, he made these wild accusations, painting wife as a literal murderous villain, and glorifying himself in the process. He did ultimately stipulate at trial that he sent this letter in an attempt to get her fired. Another example has to do with these firearms and ammunition that we've been talking about. There was this list of these firearms and ammunition that appears throughout the record. It first appears 6 months prior to trial. He submitted it as an exhibit to a motion where he's talking about wanting to get these firearms back. He then submitted this same list, unadulterated, twice more, once in a filing immediately prior to trial, and again as an exhibit at trial. In Rutherford County, we have a local rule. It's Rule 1202, and that rule requires pretrial submission of a sworn asset and liability statement in these divorce cases, and the trial court relies on that as testimony. Husband submitted this same copy of this list of firearms and ammunitions with his 1202 submission. He also submitted it as an exhibit at trial. He had plenty of time to amend or correct it, and he stood by this list until he got on the stand, and he basically admitted that he owned all these other firearms that he had secreted away with his family members. Ultimately, the trial court found that the husband was untruthful in his 1202 submission because of the fact that he placed these firearms with his brother and his son, and he didn't disclose them to the court. We still don't know what the value of these firearms and ammunition are. Yet another example has to do with his sovereign citizen status.
So, let's talk about the firearms a moment.
Sure.
Opposing counsel says there's a problem with the valuation and the identification of these firearms. How does what you have just explained to the court impact that?
Well, I think the crux of the matter is, this applies to a lot of the arguments that the appellant brings. He's complaining of a problem that he created. It's the same thing with a lot of these things throughout the case. The property that went missing while he had possession of the marital home, the property that he sold, the fact that he didn't provide adequate proof of his income, all of these different things. It's a problem that he created, and so now that he comes to the court, he first goes to the trial court and says, I've got these weapons that are mine, these weapons that are marital property, please divide them accordingly. He gets on the stand, and he has a very hard time, if you read through the transcript, an extremely hard time of identifying these firearms. He doesn't know, he misremembers some, and he's uncertain about others, and they go through a very tedious process of identifying, this firearm is this one, this firearm is that one. He's looking at a picture and trying to identify what's what, and eventually they come up, they circle on the list, these are mine and these are marital. And they submit that into evidence as an exhibit, and that's what the court went with. So I don't really think the firearms bear too heavily on the overall equitable distribution, but I think just like the property that he sold that we still don't know the value of, and these missing firearms.
Before you go further, though, let me nail down these firearms. So are you saying that they don't exist, or they weren't valued, or what exactly are you saying about the firearms in response to the appellant's argument?
Basically, my position would be that we don't know, that there are unknown firearms that we don't know what their value is. We don't have a good picture of what the value of the firearms that we do know that are in existence. We don't have a good valuation of those either. And I think
What do we do about it?
I don't know that it's my position to tell you, because I think that's the appellant's argument to make. It's the appellant's argument to, as is dictated by Rule 26B, it's the appellant's duty to come in to this court and make a case that the trial court's error more probably than not affected the judgment or would result in a prejudice to the judicial process. So,
well, you're standing here saying there are items that haven't been valued, and isn't it incumbent that something be done about that?
well, not necessarily. I don't think. By the appellant's own math, they came up with a certain valuation of this marital estate. I believe it was $482,000 total, with the wife receiving $302 and the husband receiving $180 approximately. It's our position that these values are pretty much in line with their relative incomes, which was one of the few deciding factors, the few deciding equitable distribution factors that the court had to go on. And I think the King case is very instructive on that point. The justness of the equitable distribution depends on the final results. And according to our perspective of the final results, even by the appellant's own math, it was a just outcome.
Now, I guess what I'm trying to get at is you're telling me these final numbers aren't really final because there's other things out there with relatives and whoever that we don't really know about. And is that something you want us to do something about, or you just want to what I think I'm hearing is you just want to forget about it?
Our client is happy with the outcome, certainly.
Okay.
We're not interested in relitigating it. I don't know that it would be worth relitigating. I mean, when you have a litigant who is so devoid of credibility, who is so intent on misleading the court, I mean, what it comes down to, he may have not participated in these proceedings. I think these proceedings would have gone a lot smoother if it was a default judgment, rather than having a litigant who is actively lying and deceiving and hiding assets and moving things and selling things. I think this case would have been a much easier one for the trial court to decide if husband had not participated at all. But back to where I was discussing the husband's lack of credibility. It extended well before the trial. The trial court found that we have these incidents with him causing injury to the wife. He caused the wife to have to put in all these safety procedures, alarms, detection systems. He comes back again and has this harrowing incident where he makes these veiled threats, and then he's given possession of the property. He removes all these items: a Mercedes, 2000 Mercedes car, a farm truck, a four-wheeler, all of these different things. And one thing I do want to make sure to address is that husband didn't really raise it as a separate issue, but he did hint in his briefing that the court exhibited some sort of bias. And I want to be clear on that the court was really faced with somebody. I mean, if there was somebody to be biased about, this litigant would be the one. But I really don't think the court was biased. at trial, husband's counsel forewarned the trial court that it couldn't consider fault in its equitable division of the marital estate, and in one portion of his brief, husband alleges that the trial court simply followed along with whatever the wife proposed. And our position on that would be that even if that is true, the reality of this case is that husband's testimony was so tainted by falsehoods and evasiveness that the trial court really didn't have much else to go on, besides the wife's.
That brings me to a question. You've got assuming the values that you mentioned earlier, 300,000 and 180,000. What factors did the trial court rely upon in that division?
Let's see. The first one was factor 6, which had to do with the separate property. And that one did specifically consider the firearms, that there were these firearms of unknown, possibly antiques, that were out there and not really having a value placed on them. The second factor was.
So how did the trial court, help me here, how did the trial court utilize that factor? Was it he had more than he was admitting to, or what?
I think that the trial court, a lot of these factors, and it seemed to me that the trial court was just using them to sort of move the needle. The trial court certainly, and especially based on factor 8 with the economic circumstances and the disparity in their incomes, the court was certainly not going for an equal distribution. It was going to favor the wife in this case, and I think really it just sort of moved the needle more in wife's favor. There's things out there that we really don't know what they're worth or how much they're worth, or there's things that he sold that we don't know what they're worth. We have evidence of these Craigslist ads. We have photo evidence of him removing vehicles from the properties, and we really don't know what these things are worth. So I think it's really just sort of a moving the needle kind of thing. The court, of course, is given wide discretion in making these determinations, and I think this is one of those rare cases where
Let me ask you, what did you just mean by that? The court's given the wife discretion in making these determinations.
Yes, I believe I've cited that. Herrera is one case that stands for that. Appellate courts are disinclined to disturb an equitable distribution of a marital estate. I think the discretion is Honeycutt is also another case that talks about that. It tells us that we don't need to focus on these individual awards or who got how much of this individual piece of property. The goal is an overall equitable distribution, and I think that's really the crux of our argument is were there errors in the trial court's ruling? Certainly, but were those errors harmless? I think they were. I think that.
How does this become equitable, I guess, is where I'm really trying to get. What factors did the trial court determine that made this equitable?
6, 8, and 12 were the primary factors. 12 being the catch-all that had to do with the fact that he removed and sold guns and property from the home. He failed to provide adequate proof of his income. I think that was a big factor. The only thing the trial court had to go on as far as husband's income was his testimony, because he simply failed to provide any recent income tax returns to show any proof of what he actually made or any other sort of documentary evidence. It was just all, taking his word for it. And I believe the evidence in this case makes it clear that his word really doesn't count for much. Thank you, Your Honor. Thank you.
Thank you, Mr. Payne. Mr. Lewis?
Yes, think it's important to note that throughout the trial and a vast portion of the brief is exactly the same as the argument that was just made to the court, which is essentially husband's a bad person, so therefore it's fine that he got less than equitable distribution. That seems to be the argument that I get, and that seems to be the argument at trial as well. But regardless, Your Honor, while yes, I did, because of those things, because of the facts that are cited, because of what was essentially conceded to at trial as to what husband had done, I did stand up and say to the court, look, fault shouldn't factor into this equitable distribution. That's a well-settled principle within our jurisprudence, but I think it ultimately did. I can't point to a specific thing that says the court said something to father, made a comment, it's ruling, etc. But I think the overarching theme is exactly what I think one of your honors asked Mr. Payne was essentially discretion on valuation was given to wife. Everything that could have been done that would have essentially swayed it in her favor and the overarching equitable distribution was done.
Let me
ask this
yeah.
question. Exactly what relief does your client want in layman's practical term? What relief does your client want?
My client wants the firearms to be fully divided. There are, if I look back in my Rule 7 table.
Fully divided?
Accounted for. There are, I think there's 6 or 8 of those that weren't given to anybody. They weren't addressed. They were on a list, and there was this questioning that was done by a picture that the wife submitted where she says, here's all the guns I have. And the husband says, there's more guns than that. And then there's 6 to 8 of these that are just left out in the open that are never dealt with. Then we go to the 401k issue and the stock. We want that to be considered in the valuation and divided between the parties, Your Honor. The loans and the stock valuations.
Let me stop you
Yes.
just a minute. And, I want to make sure we're talking about the same thing here.
Yes, sir.
When we review the record, will I find where your client has testified or where there was evidence introduced of all these specific firearms and valuations that he proposed?
I believe there is testimony through his testimony in the record of his best valuations on these weapons, Your Honor.
But the court will be able to identify the specific firearms that you're
Correct.
talking about, that you said the court either did not allocate correctly or did not value correctly.
Correct, Your Honor. There is a list provided, and there's testimony from the husband as to what firearms were there and what firearms existed at the time that he left the home. And I believe to all of them. He gave his best valuations to what he believed them to be worth. And I've seen on my Rule 7 table, there are several of those firearms that simply, there is no mention of them within the court's final ruling.
Okay.
So there are firearms that aren't allocated.
Correct, Your Honor.
Are those some of the firearms that he allegedly distributed among relatives?
No, Your Honor. Those are
What
firearms.
about those?
He never testified to what those were.
So there's more out there
arguably,
allegedly.
based off of that comment, which I'll be candid with the court, was not a comment I expected to receive from my client during the trial. But I'm simply basing my appeal off of the ones that we knew of that were testified to specifically with names and explanations, etc. But there was a comment made that there are firearms existing elsewhere that were not within that list.
Okay.
So I appreciate your Honor's time today. Thank you.
All right. Thank you, Mr. Lewis and Mr. Payne, for your arguments. We'll take this matter under advisement. Please call the next case.
Nancy Hardison Stokes Williams versus Ernest K. Hardison III et al.